I think the prosecutor in this case made a number of, there's the two prosecutors made a number of very perhaps controversial claims during the case. For instance, there was a lot of talk about the fact that Rittenhouse brought a gun to this event. And at some points, at one point, it was actually said directly that you forfeit the right to self-defense if you're bringing a gun to a place where you know there's going to be violence. Can you talk about that a little bit, perhaps?
I think that's an absurd argument. If you're just going into the woods for a walk by yourself, you might say, well, the chances of me encountering somebody are pretty slim, so I'm not bringing a gun. But if you go to an urban center where there's known to be a lot of crime, you say, well, that's a dangerous part of town, so I'm going to bring a gun. To say that you can't use self-defense because you purposefully bought a gun to a place where there might be violence, where are you going to bring a gun except to a place where there might be violence? I mean, that's kind of borderline frivolous.
And then there was at a later point, the other prosecutor made an argument that Rittenhouse effectively, he brought a gun to a fist fight, I think was the quote, and that he should have, instead of shooting Rosenbaum or the others, he should have physically fought them with his fists. Yeah,
the way self-defense works is you have to have the reasonable belief, and apparently that argument at least accepts the reasonable belief, and it sounds like it's more of a test of the second part of it is you have to use the force that you use has to be reasonable. The fact that you might have been able to use less force, that's not the test. The test is whether the amount of force that you used was reasonable. Maybe if he'd had a taser with him, maybe that would have been just as effective and would have, been enough. But that's not the test. Either the shooting was justified or it wasn't, regardless of whether some smaller amount of force would have been okay.
Right. It's not, the standard isn't just the jury. I mean, although I'll be fair, a lot of this is kind of the jury second guessing what you do.
Exactly. Yes.
In a situation like this. So I think that is something that should become clear to people who carry guns, like myself and others. This is what a self-defense trial looks like. You're going to be second guessed on everything you did.
Yeah. I teach a lot of classes on the law of self-defense, and people will ask me, well, what if this happens? Can I shoot the guy? And I'll say, maybe. I mean, I'm not the one who's going to decide, though. 12 other people are.
And that also gets back to this difference between the Rittenhouse case and the Ahmaud Arbery case, in that I think most people, even though you could point out some similarities, like the struggle over the gun with Rosenbaum and Rittenhouse and Arbery and his assailant, most people, I think, reasonably can see a difference between those two situations because of what you articulated earlier. And oftentimes that's what these things come down to. And I guess we should maybe cover the other three shootings here. There were three shootings, I guess, in the later part of the night after he was apparently running to try and get to the police after he shot Rosenbaum. Rittenhouse was running down the street. That's what he claims. He was trying to get to the police. And that's where he was, I guess, for a better word, attacked by the crowd, who perhaps thought that he was, had committed. Maybe they thought they were trying to detain him. I don't know. It's hard to, obviously, in a chaotic situation like that, to judge everyone's motivations. But regardless, he was obviously attacked. He falls down at this point, and then people start. One guy tries to kick him in the head, and I think Rittenhouse takes a shot at him. I guess then there's the guy with the skateboard who does successfully hit him with the skateboard after previously trying and failing while he was running. And then he's shot and killed. I think he also grabs Rittenhouse's gun at that point. And then you had the third person who pointed a gun at him before he was shot in the arm, not killed, but he testified at the case too. Actually, that was kind of a big moment in the case, was his testimony, the other guy who was armed, where he effectively admitted that, yes, Rittenhouse didn't actually shoot him until he pointed the gun at him. And this was a fairly big revelation. It was treated as such, especially on the side of people who were supportive of Rittenhouse's case. But to me, I thought that was another example of like something where it was on video the whole time. It's just kind of confirming what was already on video. And I feel like that's true of a lot of this stuff that came out during the trial.
Well, the last shooting of Mr. Grosskreutz, the one who had the handgun, it looked in the video. I mean, you could see in the video that he had the handgun, but at least from the videos I saw, it was not obvious what he was doing with the handgun. But he testified at the trial that Mr. Rittenhouse didn't shoot him until he pointed his gun at Mr. Rittenhouse, whether he did so intentionally or not. He said he pointed the gun at Mr. Rittenhouse, and that's when Mr. Rittenhouse shot him. So I think that testimony made a difference, because the video, to me, it seemed fairly clear that the shooting of Mr. Huber with the skateboard was probably justified. I mean, he's on the ground on his back and he's being hit by somebody with a skateboard. I mean, that's a pretty violent attack. It was less clear what was going on with Mr. Grosskreutz, the guy with the handgun. But then he himself testified at the trial that he pointed his gun at Mr. Rittenhouse, which I think, that justified the shooting then at that point.
Yeah, I think he had admitted to this when he was shown an image of himself pointing the gun at Rittenhouse before the shot was fired. I think it was a still image that they used in court, but I had thought that came from one of the videos, but I could be wrong on that front. It seemed to me, watching his testimony, it was fairly clear that he was just sort of admitting to what was on the image he was being shown. But yeah, I think those points are very relevant as far as those two shootings and why they would be justified. I think also what helped his case a lot is what happened immediately before those two shootings, before he pulled the trigger in those situations, where he fell down, somebody tried to kick him in the head, and then he pointed his gun at two other people who stopped and put their hands up and backed away, and he did not shoot those people. And I think that's another thing that kind of perhaps helped him in this case. Would you agree with that?
Somewhat, yeah. I think the bottom line is in all three. I'm discounting the shooting where it was an unknown victim and he didn't get shot. So the three people that did get shot, in each of those instances, Mr. Rittenhouse was either running away, had been cornered, was on his back, which I guess is the same as being cornered. So in all those, he was being attacked, and that's it's different from, like, for example, what was going on in the Arbery case. So I think the fact patterns leading right up to the shootings are really important for each of the shootings.
Yeah, certainly. What do you think this says, if anything, about self-defense law moving forward? Do you see any? This is a high-profile case, but does it have any real impact beyond just this actual trial?
I haven't heard if there's been much of a reaction right there in the community in Kenosha. I suppose there probably will be some, but as far as going forward, if it's going to change self-defense law, I don't really picture that. I think this was, even though it was sensational, got a lot of nationwide coverage and everything, I don't think it was an unusual case in terms of analyzing self-defense. I think it was fairly straightforward.